Please start. Thank you.
Hi, very good evening to everyone. I'm Dr. Bhaktina on the behalf of DentistChannel.Online. I welcome you to all you for this webinar. Today we have our speaker, Advocate Sai Sushant. He is a cyber law expert and a techno-legal consultant. We all know we have been attended one session with the same doctor. So we will be dealing the second session of this. The topic is the legal aspect of dentistry, how we will handle the legal aspect of the dentistry. So, about our advocate, he has been published various articles in international and national conference. He has received many awards. To the mention few, has been recently been awarded the best cyber lawyer of the year 2020. So we are so lucky to have Advocate Sushant for this webinar. I welcome you, sir. Please.
Thank you, Doctor. It was it's once again very enlightening to address this August assembly. So I'm extremely very privileged and honored to be part of this online dentistry channel forum once again. This has been again trying to promote different kinds of awareness on the various aspects relating to dentistry and dental practice. So today we have yet another very interesting session of the legal aspects relating to dental practice part 2. In part 1, I hope for people who have not yet gone through our part 1, please look at what we have discussed on the part 1 on YouTube. It's available on the online dentistry channel's YouTube channel. And we had some very interesting topics that we discussed upon. So in continuation to the same, I thought I should just give you a small understanding upon the various different kinds of legal aspects that you as a dental practitioner need to be aware of while practicing your dental practice. So I just wanted to just give you some very, very simple yet an idea where you can understand the various legal nuances surrounding dental practice. I don't want to take much time upon the general concepts because we already touched upon the general concepts relating to negligence and things like that. But in the interest of all, I just want to give you a basic information relating to what forms negligence and what is not negligence. And so that you as a dental practitioner, as a dentist, would be aware of whether your acts are covered under the ambit of negligence or not. So before we get into the PowerPoint presentation, I thought I should just tell you this idea about what I'm planning to cover today. I thought I should just take you through some very interesting scenarios which are not being discussed anywhere across the internet or anywhere across your associations, whether it's IDA or whether it's any other dentistry forums. I thought I should just take you through the different kinds of regulations, starting from what is negligence, and also trying to talk about the different kinds of legal nuances like Clinical Establishments Act, and what is the importance of how cyber law comes handy for dentists and dental hospitals and dental practice, because most of the people think that cyber law is something that is only related to IT professionals. But I would say that that is not the right conception. Anybody who's probably using a computer and who's using a mobile phone, who's using information or data in the electronic format, would now be required to have in place cyber law knowledge as well as awareness. So we'll discuss more in detail when we get into the topic. But just to tell you that I thought I should also give you that understanding about why cyber law is important for dental practitioners, dentists, and dental hospitals and dental clinics. And I also want to talk to you about the different legal policies that you as a dentist or as a dental clinic or as a dental hospital need to have in place from a cyber law perspective, and also talk to you about the privacy, which is now very, very important because it is now a fundamental right according to the latest Supreme Court judgment. So we'll also be discussing upon the patient's privacy and privacy related information. We'll also be talking about electronic health records, medical records, and how you need to maintain and preserve them. What are the do's and don'ts as a dental practitioner, as a dental hospital, as a dental clinic? And we'll also be touching upon some very interesting case studies relating to the dental jurisprudence and dental negligence per se. There are a lot of cases, but in a very short and concise manner, I thought I should just give you a few cases so that we'll discuss more when we have the next sessions. And also want to talk to you about one interesting area called digital evidence. So that's also going to be very, very critical in this, especially during this period of COVID-19. So in short, this is going to be the gist of my presentation today. So I hope we get good interactions. I'm open for any questions. If you have any questions, you can put them in the chat box, or you can put it to the host, and I'll be more than happy to answer all your specific questions relating to dental practice and law. So I think with this preface, I would like to start off my presentation today. Can you please connect my presentation, Doctor? Yes, please go to the second slide, please. Yeah. So I know that the image is very funny, but I must say that it is a very great learning to all of us. Now, right to privacy is no longer something that will be looked into only by IT companies or only by police. Now, right to privacy is now a fundamental right which is guaranteed to you by the Constitution of India. So, what does it mean? It means that privacy will now be required to be protected in a more better and a more intrinsic manner, because it assumes to be a fundamental right of every citizen. So no matter what, Doctor, please go to the next slide. I will have a previous slide. I will let you know. Previous slide, please. Yeah, I will let you know when to change. Thank you. So I believe that it's not just the patient's privacy that is going to be important, but the dentist's privacy, the doctor's privacy is also being a very important aspect here. More specifically, if you're working in a dental clinic or if you're working in a dental hospital, I think what needs to be understood by all the dentists or dental practitioners is that privacy of you is also equally important other than the patient per se. So with this context, I thought I should just set forth before I discuss further. Doctor, can we go to the next slide? Thank you. Now, the moment we talk of cyber law, I think I want to just tell you one thing. The moment you're using seven things, any of these seven things, you will now be required to comply or have basic understanding of cyber law. You don't need to be a lawyer to understand cyber law. The moment you're using a computer, your computer system, computer network, computer resources, communication devices like your mobiles, iPads, and things like that, and also data and information in the electronic format, you will have to understand that cyber law is now going to be made applicable to you. So you don't need to be a lawyer, you don't need to be an IT professional, you don't need to be a software engineer for cyber law applicability. If you, as a dentist, maintain information or data in the electronic format, if you make use of a computer, if you make use of a computer device, whether it's a printer, whether it's a scanner, or whether it's a laptop, whether it's an iPad, whether it's a tablet, if you're making use of any of these in your clinic, then cyber law is going to be made applicable to you. If you have them in your hospital, then if you're making use of computers, computer systems, computer resources, as also data or information in the electronic format, and also tablets and other communication devices, you'll have to understand that cyber law will be applicable to you. So that's the whole crux of the Indian cyber law. So what's Indian cyber law? In India, we have the Information Technology Act 2000. It's a new generation law. It's just 21 years old. We also have the amendment which is made in the year 2008. So we have the ITAC 2008. And in addition to this, there are some rules and regulations that have come into effect. So the two important aspects that you as dental practitioners would have to be aware is the IT rules 2021 and IT rules 2011. So if you're a dentist and if you're making use of computers, laptops, or information in the electronic format, if you're making use of pen drives, hard disks, printers, and also if you're making use of mobile phones in your day-to-day activities, then you must understand that you will now be brought under the cover of IT Act. So I will just tell you what you have to and what you shouldn't, so that you can avoid and liability. You can be due diligent at the same time not be negligent, because if you don't have negligence in place, I'll also talk about them as we go forward. Thank you. uh, the law has now come up with something called sensitive personal data or information. So this is very, very critical. As a dental practitioner, as a dentist, you have to be aware what is called sensitive personal data or information. Passwords are sensitive personal information. Financial information like credit card, debit card, bank account details, GPay, and phone pay, and things like that, all these are financial information. Biometrics are also sensitive information. Sexual orientation, gender related information is also sensitive personal data. Health records and health conditions are also going to be sensitive personal data. So, my dear dental professionals, be aware that any records or any information, including your prescription that you maintain relating to your patients in the electronic or digital format, becomes sensitive personal information under the law. Not just that, if you have a patient sign up form or a registration form, then those also would be considered sensitive personal data. The reason is you would obviously be collecting gender related information about the patient. Not just that, when you generate your receipts, your invoices for consultations and things like that, you print out a bill and give it to them. If that bill is an electronic printout, or if it's a printout from a computer, then that also becomes sensitive personal data information. The reason is it contains the health and medical information of the patient, apart from the sexual orientation, which is gender related information. And if you maintain records relating to the financial information, for example, a patient walks into your clinic, takes your consultation, makes the payment to credit card, and you acknowledge and send them a receipt to their mail or phone, and also send them, give them a physical printout, that also becomes sensitive personal information, because it contains all these health related information, as also sexual orientation. And if you mention the financial information, then those also become sensitive personal data or information. So this is the golden point that you need to be aware of. Doctor, can we go to the next slide? Thank you. Now, apart from what is sensitive, we also have something called personal information. What's personal information? Any information with which I can identify an individual. So this becomes very important. The reason is specifically from a dentist and dental practice perspective. I'll tell you how. Name is personal information, because I can identify a person using his name, email ID, contact number, address, any of the Aadhaar cards, PAN cards, credit card, and anything relating to GPay, then anything relating to even the specific diagnostic reports are also personal and contain personal information, because you can identify a person. Blood group, you can identify an individual. Now here, I would like to just give you a very interesting view specific to the dental practice. For example, if you're doing any implants, then those implant related information also can identify a patient. Because what happens ideally when you do an implant, dental implant, you actually try to note down some serial number of the implant that is given to the patient. You have some document stating that this was given to such and such a patient. So that also identifies a person. That also becomes personal information of the patient. Not just that, any teeth of the patient, any tooth of the patient, whether it's individual or complete set, is also personal information of the patient. The reason is, using the same, you can be able to identify the patient. So if you're able to do that, then that becomes personal information per se. So therefore, what you have to have a clarity is, any information with which I can identify a person, that becomes personal information. So that's sensitive and personal information for you. Doctor, can we go to the next slide? Yes. Now, this is what I was just talking to you about a while ago. What is cyber law? Can we go to the next slide, Doctor? Yeah. So this is what I was talking to you about. We're using computers, computer systems, computer resources, computer networks. That means, let me give you an example. If in case your dental clinic has Wi-Fi, and that Wi-Fi is available to all the people who are part of your clinic, then you are all automatically classified as an intermediary. We'll get to intermediaries as we discuss forward, but just to tell you that, yes, this has a lot of relevance to dental practice per se. Yes, next slide, doctor. So whatever information that I make on the electronic format, that means if I use a computer, a mobile phone, or an electronic device for the purpose of creating and for the purpose of creating a document or an information, that becomes electronic record. Thanks to Section 21T of the IT Act. What does it say? It provides legal recognition to electronic records. The reason why I'm trying to tell you this is this has very, very good relevance to the Clinical Establishment Act, as we're trying to discuss about the same in the coming slides. Because once you become a registered entity under the Clinical Establishment Act, you will now be required to maintain electronic medical records. So how is this possible? This is possible only because of the Indian cyber law, which is giving legal recognition and legal validity to the electronic records per se. Can we go to the next slide, Doctor? Yeah. Now, what's this Clinical Establishment Act? Well, if you're talking about Clinical Establishment Act, you would now be required to have registration under the said Clinical Establishment Act. So who will be required to register? If you're a dental hospital, if you're a dental dispensary, if you're running a private dental clinic, if you're any institution who was offering any kinds of services and facilities relating to diagnosis, treatment, or care. For what? For illness, injury, deformity, abnormality, or pregnancy in any recognized system of medicine, whether established and administered or maintained by any person or a body of person, whether it's incorporated or not. So what does it mean to you? It means that if you are a dentist who's practicing dental practice and who's trying to give some kind of a diagnosis, treatment, and care for any kind of illness or abnormality, then you would now be brought under the ambit of Clinical Establishment Act. So as a dental practitioner, if you're a normal dentist, you will be required to have license under the Clinical Establishment Act. If you're running a private clinic, you will now be required to have a registration under the said act. If you're running a diagnostic center, you will be now be required to register. If you're running a dental hospital, yes. If you're running a dental dispensary, excellent. All these people would now be required to have license appropriately under the Clinical Establishment Act. Can we go to the next slide, Doctor? Yes. It also includes, all kinds of issues, whether you have any kinds of independent entities as part of your establishment, which in connection with any diagnosis or treatment of diseases where pathological, bacterial, genetic, radiological, chemical, biological investigation. So any kinds of laboratory. So if you're running any kinds of laboratories or diagnostic centers, you'll now be required to register under this act. If you don't register, you will not be facing any kinds of criminal cases, but lo and behold, you will be required to pay a fine, which is amounting to 5 lakh rupees. Let's go to the next slide, Doctor. Yes. Now, let me introduce a very, very new yet very broad concept of an intermediary. So who's an intermediary? A person in between. So normally when we talk of intermediaries in the internet domain, we think that the internet service providers, the Geos, the Airtels, the BSNLs of the world are intermediaries. But let me ask you a fundamental question. If you are a dentist who's operating or a private dental clinic, are you an intermediary? Is a dental clinic an intermediary? Is a dental hospital an intermediary? Is a dental dispensary an intermediary? Is a dental testing laboratory or diagnostic center a laboratory, an intermediary? Yes. Why? Let's look at the definition. Let's go to the next slide, Doctor. Yes. Look at this question. If let's first look at the definition, then I will give you a simplistic view. Any person who on behalf of any other person receives, stores, transmits any particular electronic record or provides any service with respect to that particular record becomes an intermediary. Okay. Now let me tell you that. Now, if you are a dentist, if you're running a private clinic and you are actually trying to collect the information of your patient who's coming in for your consultation, and as a result of that, you're giving them the consultation, which is a service, you become an intermediary. So that's the kind of definition. The basic point is, if you're trying to provide any service with respect to what? Electronic records. That means if you ask your patients to fill up any form, and if you have that form electronically put in, or if you collect any data of your patients electronically, then you become an intermediary. If you're an individual, if you're a dental clinic, of course you're an intermediary, because you would now be making use of patient registration forms for the purpose of collecting patients information when they walk in for consultations. So therefore, and you're providing that consultation to them, obviously, so you become an intermediary. If you're a diagnostic center, the same applies here. If you are a dispensary, you also get covered under the intermediary concept. So this is a very broadly defined term. So intermediary does not necessarily mean only the internet service providers, only the telecom service providers, or others. It also includes dental clinics, dental hospitals, diagnostic centers, dental dispensaries, and also individual dentists who are providing consultation services to their patients by collecting their information and storing them electronically and providing service to them. So this is the broad definition of intermediary. Now, let me also give you a very different kind of a perspective here. If you, as a dental practitioner, have Wi-Fi in your respective clinic, you become a network service provider. So who's a network service provider? Again, an intermediary. So therefore, if you have a Wi-Fi in your dental clinic, and that Wi-Fi can be used by patients as well as by your staff, as well as by you, then you become a network service provider under this law. So when you're a network service provider, you automatically become an intermediary. So we'll talk about the do's and don'ts of intermediaries as we go forward. Can we go to the next slide, doctor? Yes, please go to the next slide. Yes. Now the Intermediary Guidelines 2011 has brought some kinds of due diligence parameters upon intermediaries. Now you will say, so what if I'm an intermediary? If you're an intermediary, you will not be required to exercise due diligence under the law. Now you will say, what is the due diligence that I, as an intermediary, would be required to do? Simple. The first reason is, if there is any kinds of issue with respect to any grievance, then the said intermediary should take down that respective content or any grievance within a span of 36 hours from the time they receive it. So if, let's say that you have a particular website, you have a particular mobile application, you have something like that, if there is any issue with respect to any content, if you're having a solution, let's say an IT solution developed and used in your private dental clinic or in dental hospital, somebody points out and says, hey, this is something which is objectionable, this is something that is not that is affecting me, and they send you that information by email, you will be required now to act within the 24 hours for sending them an acknowledgement, 36 hours for taking the content down. If you don't do so, you get exposed to legal liabilities. Okay, we'll discuss that in a detailed way. Let's go to the next slide. Yes. Now, if in case you disclose any kinds of personal information, then while providing services, so this is what happens. See, I want to just give you this idea. Of late, I've been seeing a lot of dental practitioners as also medical practitioners use this information relating to the patients on social media. I understand, as doctors, as medical practitioners, as dental practitioners, you might have a great skill and expertise per se in your own line of specialization, but that doesn't mean that you expose the personal information of the patient upon the social media without their consent. Specifically, I see that a lot of people post reports, photographs, before and after. All of these are posted on social media, whether it's Facebook, whether it's Instagram, and whether it's Twitter, and things like that. So don't do that, because you do that, this section can be made applicable to you, and you would have to face imprisonment of up to 3 years with fine up to 5 lakh rupees, or sometimes both. So that's something that I want to advise all the dental practitioners. So do not do that, because you can be in for legal trouble per se. Yes, doctor, can we go to the next slide? Yes. Now, what does the law say? The law says if you're an intermediary, do simple things, not very complicated. Number one, comply with the law. Number two, exercise due diligence while you're discharging your obligation under the law. Number 3, do not partner, do not sleep in bed with somebody who's violating the law. Number 4, if you do these, your life is safe. If you don't do any of these, you get exposed to two kinds of liabilities. One is civil and another is criminal liability. Now, for your simple understanding, let me tell you, civil always talks about damages by way of compensation, monetary compensation, and things like that. Criminal always relates to imprisonments, penalties, fines, and things like that. So these are the two kinds of understanding that you need to have as a dental practitioner. Let's go to the next slide, doctor. Civil liabilities. So civil liabilities could be damages by way of compensation up to 5 crore rupees per contravention. So my dear dentists and dental practitioners, if you do 5 contraventions, you could be in for civil damages up to 25 crore rupees. And apart from that, criminal exposure, which would be ranging from 3 years to life imprisonment, fine ranging from 1 lakh rupees to 10 lakh rupees. So these are the different kinds of exposures for you as intermediaries in case you don't exercise due diligence or you're negligent in implementing due diligence. Can we go to the next slide? Yes. There's apart from that, there's also a liability for non-compliance, which you could face a penalty or you could face damages up to 25,000 Indian rupees per se. In addition to this, can we go to the next slide, doctor? See, in addition to this, if you're a private dental clinic, if you're a dental hospital, if you're a dental dispensary, if you're a dental diagnostic center, or if you provide any kinds of laboratory services, then apart from facing civil damages, you could also be in for criminal cases. Criminal cases cannot be just filed upon the doctor, but even upon the establishment, the top management, the middle management, and each and every stakeholder who's responsible for the said amount of negligence. So I'll just tell you how does it work in the real sense. Can we go to the next slide, doctor? Yes, thank you. Now, if you are a dental practitioner, if you are a dental hospital, if you are running your private dental clinic, if you are a dental diagnostic center, if you are a dispensary, if you are providing any kinds of laboratory services, you will now be required to have in place cyber law compliance. So what do you need to have? Simple things. You need to have in place a privacy policy. A privacy policy talks about what kinds of information is collected from the patient, what is sensitive, what is personal, and what is the purpose, how is it going to be used, to whom all is it going to be shared, and in case of any issues, who is to be contacted, what measures you have in place for protecting the same. So you will be required to stipulate all these under your privacy policy. Now, number 2, you would be required to have adequate terms and conditions relating to the same. Third, as a dental practitioner, as a person running a dental clinic, as a person who's running a dental hospital, as a person who's running a dental dispensary or a dental diagnostic center or a laboratory, you would now be required to have in place a grievance mechanism. Now, what is this grievance mechanism? You would be required to appoint a grievance officer, and the grievance officer's name and contact details would have to be specifically mentioned to the patient. So in case the patient has any grievances with respect to his or her personal or sensitive data, they'll be contacting and sending the grievances to the grievance officer. As a grievance officer, you are responsible for addressing the same within a maximum of 15 days from the day you receive the complaint. And apart from that, if you specifically receive any grievance, the same has to be sent, and it's the same acknowledgement has to be sent within 24 hours upon receiving the same. Apart from that, you would now be required to have a user agreement specific to the sensitive and personal data that you collect from your patients. So these are the 4 different legal policies that you as dentists would now be required to have in place in case you're collecting, storing, processing, handling, and transmitting sensitive personal data and personal data of your patients. Let's go to the next slide, please. Yeah. Now, very important aspect that I want to bring in here is if you are a dental practitioner running a private dental clinic or working for a private dental clinic, or if you're running a dental hospital or a diagnostic center or a dispensary, and if you now, by chance, because today is the world of globalization, right? you have a lot of foreign nationals walking in for consultations to your clinics or hospitals per se. Now, if you happen to, by chance, uh, look at any person from European Union or the GCC countries, you will not be required to exercise compliance to this particular legislation called the GDPR. It's called General Data Protection Regulation. It's a very small regulation, but I must tell you, this has now become a mother legislation and for various data protection laws across the world, including the country's personal data protection bill, which is in progress. So I would say that if you're collecting sensitive personal or personal data of the foreign nationals specific to European Union, you would not be required to have GDPR compliance in place. So think twice before you actually try to take up cases relating to foreign nationals, specifically from the European Union. The reason is most of the cases in the dental practice are elective. So you cannot take the defense that I never knew that such and such a law exists, because we live in a country which says ignorance of law is no excuse in the eyes of law. So just because you are a dental practitioner does not mean that you should not have legal awareness. The law expects you to have certain due diligence parameters and some basic awareness about what you should and what you shouldn't under the law. So I think this is the learning that I would like to give you, because in case you're trying to take up any of the cases relating to any patients who belong to the European Union, then GDPR compliance is mandated. So GDPR compliance means that you would be required, just like you have a privacy policy, you would be required to have a privacy statement. You will be required to have a data protection officer, just like we have a grievance officer. You would be required to have proper consent forms. So we'll also be talking about the consent forms as we go forward. But just to tell you that these will be very, very important aspects from a GDPR perspective, because GDPR gives paramount importance to privacy of patients' data per se. Let's go to the next slide. Yes, I have some very, very interesting cases that I thought of sharing with you. Please put it over there. Number one is the case which is called the Delhi dental negligence case. So in this particular case, what happened is that the Consumer Forum in Delhi had awarded the dentist to pay a compensation of 2 lakh rupees to a woman for giving her faulty treatment and even threatening her when she pursued a case against him. So this is very, very important, my dear dental practitioners. If there is a negligence upon any of your acts, be vigilant. Do not engage in acts that are causing any kind of threat to the patient. Because don't forget the fact that if you're trying to threaten a particular patient, then forget you being sued for medical negligence and things like that. There can also be criminal cases filed against you for the same threat. So I think that's something that we'll all need to be aware of. Not just that, even if you do that electronically, then you would also be facing similar kinds of penalties. Don't forget the fact that threatening doesn't mean threatening physically. Even in threat through email or SMS or through phone call can also be a threat, and that is enough for filing a case against you. Now, in this case, the respective patient was a freelance writer, and they had approached the doctor and at his clinic, and with a specific complaint of the pain in her first molar. So she was initially advised root canal, but but finding the same was not possible. So she was told to go for a crown bridging. She paid 6,000 rupees for a model of crown bridge. Now let me tell you, my dear dental practitioners, if you're trying to provide any kinds of services for a particular fees, then you would not be brought under the ambit of consumer protection law per se. So you cannot get away with any kinds of issues when you provide consultation services. So as I told you, in this case, the complaint was pain in the first molar, and she was advised root canal. But once the same was done, she was told to go for a crown bridging, and as a result, she paid 6,000 rupees for a model of crown bridge. But however, there was some kind of difference in the opinion. After treatment, she started experiencing a pain. The doctor advised her full capping. So following further discomfort, he tried to remove the crown, but the same failed. Then the particular patient went on to AIMS for a second opinion. Uh, then she was informed by AIMS that there is an issue with regard to the fixing of the crown, and the same was faulty, and the same should be removed. So this is another issue, my dear dental practitioners. So when you do not have expertise in a respective specialization, please refer the patient at the first instance itself to the respective specialist. Otherwise, you will land up in these kinds of scenarios per se. Now, she approached even the dental council. When she confronted with the doctor, saying that she got a second opinion, the doctor tried to uh, be harsh and demanded her to give the name of the person whom she had approached for a second opinion, so that he could complain against that respective doctor in the dental council per se. Now, the opinion of another doctor from another respective institution was taken, and that opinion, third opinion, also was same as the second opinion. So the patient then went on to complain before the dental council. Then the Tamil Nadu State Dental Council had actually taken up this, and because it was the council that has given the license to practice to the respective dentists, though this was in Delhi per se. Then uh, she later appeared before the Tamil Nadu Dental Council, and however, the doctor did not appear before the same. And the finally, what I want to tell you is that there is a deficiency in service in this particular case. So what happened? This amounted to negligence, because it's a breach of duty. Now let me tell you, negligence means only three things. I will call this as three Ds: deficiency. That the first thing I will tell you is breach of duty of care. And as a duty, if you breach duty of care, that means you did not exercise your duty of care. Somebody suffered a default, and the default has happened only because you did not follow your duty of care. If these three elements can be proven, then it amounts to negligence per se. So you failing to exercise duty of care, and because of that there's an injury, and that injury is specifically arisen because of you being because of you not exercising your duty of care, or because you breached your duty of care, then that amounts to negligence per se. So in this, a negligence was clearly established, and the doctor was asked to pay compensation of 2 lakh rupees within 1 month, failing which he had to pay an interest of 6% per se. So this is a very interesting dental negligence case per se. Can we go to the next slide, doctor? Yes. So this is another interesting case in Bangalore. A woman had actually approached uh, the consumer forum in Bangalore after her root canal procedure was not done properly. As a result, she suffered with infection and swelling of gum, and actually severe pain. So finally, what happened here is that the compensation of 60,000 rupees was awarded in this particular case. So what happened? Let us just look at the case so that you'll understand it more better. So this patient was a patient residing in Bangalore, and she had approached a particular dental practitioner in the private clinic in the nearby locality, and sought the preliminary treatment for her pain. So the pain was, she was suffering with severe tooth and gum ache. So the dental practitioner recommended that a root canal has to be performed, and which was carried out at the respective clinic. And she was asked to visit again to fix a tooth cap. But within few days, the patient started developing an infection, for which the doctor gave her some medicines. But the situation went on persisting. So therefore, the dentist recommended that let's go for a CT scan. So which very clearly became evident that there was something that went wrong during the root canal procedure was established from that respective CT scan. So thereby what happened in that case, she approached another private hospital where dentists asked her to immediately remove the filling done as part of the root canal procedure. So she also visited another dental facility where doctors confirmed that incorrect drilling on the right side of her mouth was done, and she had to undergo a fresh surgery and subsequent treatment in order to recover completely from the pain. So she was absolutely infuriated with what happened, and she sent a legal notice to the respective dental practitioner for 10 lakh rupees as damages. So therefore, again, this was the whole thing that has taken place over there. But what really happened is the consumer forum went on to determine that this was indeed negligence on the part of the dentist while performing the surgery, and the court did not absolutely uh, encourage any other claims, and possibly they pronounced a verdict that the dentist will be required to pay a compensation of 50,000 rupees for negligence and 10,000 towards the litigation charges, and everything was supposed to be paid within 60 days, failing which it becomes contempt of court again. So what really becomes important is, please do have proper documented versions of what's of the procedure that you are actually doing, and please be aware that if you claim to be a specialist, or if you have a specialized skill in this respective specialty, only then take it up. Otherwise, I would recommend that please take it up with another professional. Please send out a referral letter so that there will not be any kinds of medical negligence in your acts of treating the patient. So this is one another case that's very, very important per se. Just to understand that, the procedures, if they're not adopted well, or if they're not performed well, and as a result, let me tell you, one golden factor is, there need not be any kinds of further things, that any complications for the patient to file a case. If you have performed a particular treatment, and as a result, if a minimum, let's say, some pain is suffered by a patient, and they come to you, you're not properly treating that, then that itself a ground for medical negligence per se. So be very, very cautious when you're actually performing any kinds of these dental procedures. Be fully alive to the fact that these procedures, in case they cause any kinds of after effects or consequences, you should at the first instance list all the probable complications, and then disclose the same in writing to the patient. And second important aspect, please make the patient aware if you think that there are any complications that are going to arise. Number three, if you think that it's going to be alarming, if you think that it's going to be complicated, then I would say please stay out of that, because all these cases that you take up as a dental practitioners are elective in nature, and they're not absolutely compelled cases. Let's go to the next slide, doctor. Yeah, this is one more interesting case, which is in the state of Kerala, specifically a place called Todupuzha. So in this particular case, what has happened is that the complainant, who is a patient, the patient had complained against the doctor, claiming compensation of 1.24 lakhs, specifically, to be precise, 1,24,150 rupees, on the ground of deficiency of service on the part of the dental surgeon in treating her, specifically the complaint relating to her left premolar and canine teeth. So the doctor also appeared in the consumer forum. Of course, there's a denial of the deficiency in service. And further, the dental practitioner contended that there was absolutely no negligence on his part in treating the complainant. But what is the learning curve in this particular case is that, when he conducted the root canal treatment was done for the upper canine of tooth based on the complaint given by the patient, and the doctor told he had nothing to do with the upper premolar. See, the problem here is that if there is something, you'll have to make the patient aware of the same, and apart from that, you will be required to note down all the history of the patient, and maintain a proper record, so that these kinds of issues will not be arising thereafter. So that is the whole point in this particular case. Finally, what has happened is that, the courts absolutely ordered to pay a compensation of 15,000 rupees with the cost of 2,500 rupees, and that had to be paid within a span of 1 month, with failing which an interest of 12% was charged. So if you get into the facts of the case, let me tell you that even not proper even suppression of the facts to the patient also amounts to medical negligence. That's the whole crux of this particular case. So don't suppress any facts from the patients. Let them know the actuals. So that's the learning curve of this particular case. Doctor, can we go to the next slide? Yes. Now, digital evidence will be very, very important as far as dental cases are concerned. So, one thing that I want to ensure and tell you is that anything today that you create, whether it's your electronic medical record, whether it's your electronic prescription, or whether it's any kinds of electronic record that you mentioned relating to the patient's information, everything is digital and everything becomes electronic record, as I told you, under the IT Act. And anything which is electronic record under the IT Act can be a digital evidence in the eyes of law. So let me tell you very, very, very interestingly that if you, for example, let's say that you want to challenge or you want to present your prescription or patient record before a court, that you exercise your due diligence, that you were not negligent in this particular case, that and you did not suppress any fact, then how do you establish the same before the court? You can do so by taking a printout, or you can do so by producing the said electronic record directly in the court. So how do you produce it? There are two kinds of evidence. For this, you need to understand what is called primary evidence, what is called secondary evidence. I won't go too legal into it, but as a dental practitioner, it's very important that you understand this, because you now are also dealing with a lot of patients. Specifically, you're maintaining electronic records, which is mandated under the Clinical Establishments Act. So therefore, it is very important that you understand what are the kinds of legal nuances relating to digital evidence. So let's say that you maintained the proper electronic record of the patient, and under the said record, you have put all the requisite information, including the probable complications, but something went wrong and the patient sued you for negligence. Now you can take the defense that I maintained the record, I informed the patient about the probable and anticipated consequences, and the patient was ready to go ahead. So how will you be able to prove that? If you have an electronic record of the patient, that becomes digital evidence. But again, in order to understand which is primary, which is secondary, I will just give you a simple example. If you produce the same device from which you created the electronic medical record, let's say that you created the electronic record of a patient by using a particular laptop. If you produce that laptop directly in the court, that becomes primary evidence. Suppose you take a printout of the same and you produce the printout, or you take the screenshot of the same and produce that screenshot before the court, that becomes secondary evidence. So primary evidence is when you're directly producing the device from which you created the electronic health record or medical record. The secondary is the copy. That means, how do you identify the copy? Which is, if you extract something from the original, that becomes a secondary evidence. So these are the two principles relating to primary and secondary evidence. Now, what happens if there are primary evidence? If there's a primary evidence, no issue at all. The court will accept your electronic medical record, and it will treat that as a legally admissible evidence. That means it is admissible in the court of law. Now, what if it is a secondary evidence? Suppose you do not have the laptop, you cannot take the laptop from where you created the electronic record of the patient to the court. Then what do? You take a printout of the electronic record and you submit the same to the court. So in that scenario, what happens specifically is that this becomes a secondary evidence. So when it's a secondary evidence, you will now be required to have in place a certificate. What is the certificate? This is called Section 65B certificate. Now, what is the certificate? Who can issue the certificate? And how does the certificate have any relevance to you as a dental practitioner? These will be the primary questions that you'll all have. Okay. Now, let me tell you one by one. As a doctor, let's take the example of diagnostic center. You will have a better understanding. Now, you have ordered, you told the patient, you advised the patient to go in and take a particular test, let's say an X-ray, a simple X-ray from a diagnostic center, and get the report. So the patient, on your advice, goes to the diagnostic center, takes the X-ray of their teeth, and then comes back to you with the report. Now, what does the radiologist who's writing the report actually? How does he come to an understanding? They come to an understanding based on whatever they saw. So that is, whatever they saw, they report it. That is called matter of fact. That means whatever you saw, whatever you observed, you have recorded them in your report. That is called matter of fact. Now, what is the second one? Expert opinion. so once they take this report and X-ray, they come to you because you are an expert in dental practice. So therefore, they come to you for consultation. So what do you do as an expert, medical expert, or as a dental practitioner? You take that and you further prescribe the treatment that is to be done, whether it's root canal, whether it's any crown, or whether anything else, surgery has to be done. You take the call depending upon the expertise that you have. So your expertise is based upon the report that is being given. So take this to be the certificate. This is called the 65B certificate. Now, the 65B certificate contains two parts. One is matter of fact. That means whatever you saw and observed. Second is an expert opinion. Now, in medical legal cases where it involves a digital evidence, that means you're relying on the electronic health record of a patient, then what happens in this case? The first thing that you will have to understand is that whatever you as a doctor have observed, you can yourself give the certificate. That is called matter of fact certificate. So you will say this is the medical record I created. This is the kind of things I've observed. This is the model number of the laptop I created. This is the path of the file where I stored. And this is the kind of software I use, whether it's Microsoft Office or PDF or any other software for that matter. This is the software I used, and this is the date, this is the time. Everything will be given by you in this matter of fact certificate. Now, who's having the expert opinion? There is somebody called examiner of electronic evidence. So these examiner of electronic evidence are notified under section 79 capital A of the ITAC. So you have some forensic labs. For example, the Central Forensic Science Laboratory in Hyderabad. Then you have the laboratory in Pune, in Gujarat. So likewise, there are so many labs that are recognized as examiner of electronic evidence. So in case the court requires the expert opinion, then whatever evidence you produce, the same will be sent to them. They will send out a expert opinion. So just like the example I told you. So this is how digital evidence is very important in for dental practitioners, specifically because you're maintaining electronic medical and health records under the Clinical Establishments Act. So this is the very important fact which is not much spoken of anywhere on the internet or not available much anywhere on the YouTube. I just wanted to convey this to you because it's very, very important that you are aware of the same so that you are not on the wrong side of law. You are complied and you don't need to face any kinds of legal troubles tomorrow. So these is in short something to do about digital evidence per se. And of course, we have even the forensic orthodontology and things like that, where they talk about preservation of dental evidence and things like that. I don't want to get into that, but just to tell you that yes, this is how digital evidence assumes more importance in medical techno-legal cases. I will call this as medico techno-legal case because it involves the technology. It is to do something with the medicine, which is because it's a medical legal case involving technology. So therefore, medico techno legal case is what are the order of the day presently. Can we go to the next slide, doctor? Yeah. So I also thought of sharing some very interesting yet eye-opening cases with you, specifically not just from the medical legal perspective, but also from the medical techno legal perspective. So let me tell you this very, very interesting case. This is the cybercrime case. We have 3 cybercrime cases that I would want to discuss, and this is one of the very interesting cases per se. One second. Yes. Now this happened quite recently, where this happened in Chennai. Specifically, a metropolitan magistrate in Chennai has taken cognizance of this case against a particular dentist who was the managing director of a respective dental hospital in Chennai per se. So what has happened in this particular case? Yes. So this was something relating to sending an email which is containing defamatory content to various maxillofacial surgeons, specifically by an employee. So what happened in this case? The dental hospital's employee started sending defamatory content to various maxillofacial surgeons through email specifically. So this matter went on to be filed with the cybercrime cell, and they've actually charged even the hospital and also the respective managing director of the hospital. So this is where I said the top management also will be facing legal liabilities per se. So this is a very interesting case that I thought of sharing with all of you. So be very, very careful. Ensure that you have proper policies. Let not your employees misuse your clinic's IT infrastructure, including emails, including computers, including devices, including internet and things like that. So I would require you to have in place appropriate documentation so that you can immune yourself from legal liability in case of any of the misconducts done by your respective employees. Failing which, you would be also part of this, because as I told you, you will have to demonstrate your due diligence, that you were not negligent per se. So how do you establish that? These legal policies would enable you to establish legal compliance. Can we go to the next slide, doctor? Yeah. So this is one more very interesting scenario. The dentist in this particular case clicked on one of the links sent by the patient, and as a result, the doctor lost out 20,000 rupees per se in this scenario. So a dentist and the owner of a particular dentist pathology lab became a victim of a cyber crime, because people started posing and impersonating them as patients and duped them with the amount that I spoke of, 20,000 rupees for one transactions, multiple transactions, and the total loss was about 45,000. So specifically in this era where we are making use of digital payments, including Google Pay, including Phone Pay and things like that, please don't fall under the ambit of sharing 2 rupees or 1 rupee initially and then clicking on the links. As a dental practitioner, please be aware that do not click on any links that are sent by your patients, or for that matter, do not share any links to your patients, because if your patient also clicks on that to make payment to you, as a result they get duped, then you would also be facing criminal and civil charges per se under the Indian cyber law. So be very, very careful from relating to the same. So this is yet another case that I would want to tell you. Let's go to the next slide, doctor. Yes. So this is another very interesting case per se. It's a case of something called phishing, which is a cyber crime. That means you impersonate. It's almost like a fake page impersonation, and you start collecting information. This mostly happens relating to bank frauds and things like that. We've seen a lot of cases where people lost out money just or got duped with fake login pages relating to banks, specifically net banking. But in this case, what happened is a person was actually has filed a complaint of cheating against another person who claimed himself to be a cyber cop, and who told him that, there is a case of medical negligence registered against you in such and such a police station, and the FIR also was number was given, and as a result, the dentist or dental practitioner thought that this is a genuine case, and they were apprehensive of the same, that they're going to be arrested. So they went on to talk to this guy. This guy told them to pay such and such an amount to him through online transfer, and he said, "I will ensure that the case is dropped." So the dental practitioner believed the respective person and transferred the amount, and as a result, instead of just losing some amount, the entire amount was in his account was actually taken away by these cyber criminals. So be very careful when you get calls relating to medical negligence per se, and because people try to exploit your fear and panic. So I think that's the fearware is one of the new kinds of cyber crimes that is starting to emerge during this period of COVID-19. I think it's very important that you as dental practitioners stay alive to the fact that these kinds of calls can also be made to you, claiming that a case of medical negligence has been registered with the police, and the same also citing a fake FIR number and things like that. Even they will make it so genuine that they will also tell you the details of the case. They will also tell you the FIR date, the number, the police station, and the investigations officer details and things like that. Don't fall under the trap. So this is another learning curve that I want to share with all of you. Yes. Now, this is one another case in Noida where, unfortunately, a man having toothache had attacked the dentist because of an argument of waiting overtime. So, because the patient was asked to wait for some time and the time was getting, I mean, he had to wait for a little more amount of time. This caused a lot of irritation, and as a result, the patient became furious and he attacked the dentist with a knife thereafter. So therefore, he was booked under IPC 307, attempt to murder and things like that. But this is yet another case. Be very, very watchful of the patients today. Next, can we go to the next slide? Yeah. So dental databases are also something that's going to be very, very important, my dear dental practitioners, because once you maintain dental records of patients, and these dental records obviously contain sensitive personal data or information and personal information relating to patients, then if you maintain that, you would be required to have in place cyber law compliance, as I was talking to you about, have those 4 policies in place, collect proper consent from the respective patients, also protect your dental database by registering a copyright. You can take random printouts from your dental database and go ahead and file a copyright application. So copyright gives you a lot of protection from the lifetime of the author plus 60 years. So you'll have a lot of protection per se. So anybody tries to copy your dental database, you can sue them from an intellectual property per se as well from a copyright law perspective. Now, copyright law also brings in huge amounts of penalties and criminal charges against people who are indulging in any kinds of activities infringing upon the copyright of any person. So these are also very, very important per se. Yes, let's go to the next slide. I have some more interesting cases that I would want to share with you, but I think if in case we have time, I'm not sure whether running out of time or not. So let me just ask the host: do we have some more time, or is it time to wind up? Doctor, do we have some more time, or can we, or are we required to wind up?
No, sir, you can continue.
Okay. Then I would also try to give you some more interesting, I won't say cases per se. I would just want to tell you some very basic tips with regard to maintenance of these electronic records of your patients. First thing, please ensure that you have a proper record keeping mechanism. What do you mean by record keeping mechanism? Record keeping is very simple. If you're storing all the patient's related information in electronic format in a computer, please have certain backups in place, then have reasonable security practices and procedures. Now, what are reasonable security practices and procedures? Have proper physical, managerial, technical, operational measures. Physical, for example, I'll just give you a quick example. I won't go much into this. Physical measures: have access control, have proper physical security to the places, to the devices, have physical controls. Second, technical: have passwords, have firewalls, have something like antivirus and anti-intrusion related tools. Please purchase them. Please keep on updating them, because you're dealing with sensitive personal information and personal information of patients. As I told you, the value is very intrinsic. It has high amount of value. You can be sued both for civil and criminal penalties per se. And second, ensure that you have also the proper operational mechanisms in place. That means people who are operating this respective electronic medical records also should be sensitized and aware about the importance, about the value of the sensitive personal data and information and personal information that you actually collect. So that's another important aspect. Then please keep on having regular backups, so that any issues, you can still have a backup in place. Ensure that all of these are only in proper format, read only format. I would recommend read only format, because if you give the option to modify or share, any of your employees also may indulge in sharing the same to the competitors. So be very careful in the same, and ensure that in case you want to call a computer technician, please ensure that this data is protected in either with passwords or with encryption, so that this is not falling under the ambit of any of these other people. And irrespective of whatever changes the technology, I think the old data should be completely preserved and maintained, because under Section 67C of the IT Act, you will not be required to preserve data for a minimum period of 1 year per se. So ensure that the records of the patients are still maintained in a proper way, even the old records. And at the same time, ensure that the privacy of the customer, of the patient's information is maintained. So because health and medical information, information relating to their personal privacy, like if you capture a photograph, if you capture any personal details, ensure that they're all protected well, and ensure that you have proper privacy policies even for the same. And my advice to all of you is, in case you're using third party solutions, a lot of third parties are coming up with ERP solutions for dental management, dental practice, and like, dental clinic management, dental hospital management, and things like that. Be very, very careful, because if you share these personal information with any of these third parties, ensure that you have proper agreements in place, proper policies in place. Also intimate your take proper consent from your respective patients relating to the said information transfer to the third parties, failing which you can be exposed to civil and criminal liabilities apart from medical negligence per se. So all these are some basic measures that I would want to tell you. So some interesting pointers from a record keeping perspective. So apart from that, as I told you, at the initial level, all these cases that you take up who are elective in nature, in case you think you do not have the required requisite expertise to respectively handle this specific case of the patient, please ensure that you document it and you have a proper reference letter. We can also call that as a referral letter. So you can adequately mention about the patient's details over there, the summary and the health conditions, and what is the treatment that is required, and why are you referring them to the respective specialists. I think all these can be clearly documented to ensure that you have, at the first instance, exercised due diligence and you are not negligent in exercising your duty of care per se. So this is a second aspect that I would like to talk to you about, that is the referral letter. Now, the third thing that I would want to tell you is relating to the patient's consent form. We have some standard consent forms. We do provide patient consent forms and doctor consent forms to dental hospitals as also dental clinics. We can do that on a one-on-one basis. You can get in touch with us. Uh, the organizers would be displaying my contact details, or my contact details are available at the first slide of the presentation today. And what I would want to tell you with specific, in simple sense, with regard to consent is, please ensure that the consent is captured in a proper manner. Proper manner is they sign it properly after going and give them an option to either decline or accept. If you're doing that electronically, please give them an option to accept or decline. If you're doing that manually, even give them an option, either they can accept it or they can decline it. Number two, take specific consent. For example, if you're collecting their sensitive personal information for a respective consultation, specifically mention that in the policy and take specific consent. You can't take one generic policy, one generic form for all kinds of. You can't take one generic consent for all kinds of practices. So be very specific to the consent that you take. The specific consent for specific procedures is advisable. Do not have a general consent which is applicable. Even if you have a general consent, that is not legally valid in the eyes of law. So that is something that I would want to tell you. Number four, ensure that the patient consent forms are in very simple and yet manner which is complying to the rules and regulations. Keep it very simple. Don't have to and have pages and pages. As I told you, whatever is required under the IT rules, you can make that very short and concise. And then you can put it in a very simple language that your patients are actually understanding why this particular form is required and why are they to sign on this. Do not force them, but just tell them that this is required in case we want to take consultation because of these particular reason. Please also ensure that your staff are sensitized about the requirement of taking this consent from the patient for consultations and specific to the sensitive personal data and personal information that your clinic, your hospital, your diagnostic center collects. So this is something that I want to tell you. Please ensure that a detailed medical history is also taken. So this is one another point that I would want to tell you, because if you don't document it, then the element of negligence can be clearly established upon the part of your activity. So like the case I was trying to tell you, the root canal therapy. So please ensure that the complete history of the patient is recorded and is maintained properly. And one another advice to all of you is that please ensure that in case you want to have this consent forms, please get that signed before the consultation, so that the patient actually understands whether to go for the consultation, or whether he wants to decline himself, or decline from going to the consultation per se. So these are some normal due diligence parameters in regular. So specific, we can deal it on a one-on-one basis per se. And apart from this, there are no blanket or straitjacket formulas. Be very, very careful when you're dealing with NRI people. This is one another aspect that I want to tell you, because there are so many different cases that we have come across, specifically relating to the foreign nationals, because the foreign nationals can sue you in India for alleged defamatory in service or deficiency in services per se. In one of the cases, I can tell you that in Chandigarh, even the Chandigarh court denied bail to the respective dental practitioner, because a complaint was filed by a United States patient, alleging that there was some kinds of an issue with regard to our upper jaw after the treatment which was done by the respective dental practitioner. So be very careful relating to that, and ensure that you have all these policies in place, so that you do not land up in any of these aspects per se. So I think these are in short some things that I would want to just make you aware of. Of course, it's going to be a very interesting scenario as we discuss forward, because there are a number of legal, medical legal, dental cases that I would want to share. But I think all that cannot be told in a span of a session which we are discussing today. I think we'll look at having separate sessions for talking about the specific case studies. And also, one another aspect that I want to tell you is relating to the 3D printing related implants. So 3D printing is also another new technologies which is used by a lot of dental practitioners today for the purpose of doing dental implants to their respective patients. So we had a discussion, very elaborate session on dental implants, a legal view in the World Implant Expo, which is hosted by the same forum. So do check out their videos where we have detailedly discussed about the legal nuances. But there are lots of things that you would be required to know from a dental implant perspective also, both if you are a patient as well as if you are a doctor. So I would also be more than happy to take another session on probably the dental implants, as also looking forward for even a session on forensics, or forensics relating to the dental practice, forensic orthodontology, because that involves again the concept of evidence, digital evidence, and things like that. Police also rely upon these practitioners in number of criminal cases. So that'll be very interesting to look at those areas as well. So I think more or less we have covered most of the topics that I told you in the beginning. Doctor, can we go to the next slide? Yeah, so I have some funny images. Yeah, previous slide, please. Yeah, so what are dental x-rays called? Toothpicks. So next slide, please. Yes, this is also something that because we come from the legal fraternity. I thought, no offense to anybody here, but just to tell you that yes, to make the session more interesting, I thought I will get all of these to picture. Can we go to the next slide? Yeah. So what is this necessary is only what is required. So given the amount of span of 1 hour, I thought I should just give you a holistic yet a bird's eye view upon these areas specifically, because these are very newly emerging areas, and I believe and understand that this is of paramount importance to the dental practitioners today. Most probably because everybody is now required to maintain electronic health and medical records relating to patients, given the Clinical Establishment Act and the rules and regulations made thereunder. So next slide, please. So thank you very much, one and all, for this particular session. Thank the organizers, thanks the host, because in a very, very short span, I believe that the host has helped me move my presentation and slides. Big thank you to all the participants and all of us who are watching us on social media, Facebook, YouTube, and also the organizers of this particular webinar, including the online dentist forum and channel, for giving me this wonderful opportunity to share with you the dental jurisprudence, or for that matter, legal aspects of dental practice, part 2. So it was yet another enlightening and a very thought-provoking communication. I believe that these kinds of sessions would help to address and bring about a very good amount of awareness relating to the general dental jurisprudence, not just among the legal practitioners, but also among the dental practitioners who are now be required to exercise due diligence and due care under these laws per se. So thank you very much. So it's been pleasure to talking to all of you this evening. I'm open to any questions if there are any.
Thank you so much. So participants, you can leave your question in the question answer box. We will be discussing the question. Hello, sir. Hello.
Hello, Dr. Advocate Sushant. Are you there?
Hello.
Hello, Sushant sir. We are not able to hear you.
Sorry, I
Hello.
didn't get you. I didn't get you, please. Was there any question asked?
No, sir, not yet. Anyway, thank you so much for the wonderful section. I would like to thank you on the behalf of Dentist.Online channel for the wonderful session.
Thank you, please. Thank you, Dr. Thank you, Doctor.
Martin.
And thank you, Siddiq, for this wonderful opportunity. Looking forward for more interactive sessions in the future.
So today we will wind up the session. I would like to thank you, all the participants, for your patience. So please do follow us on Facebook, Instagram, and YouTube. Thank you so much. Very good evening.